United States Court of Appeals for the Second Circuit. Sitting as Associate Justices are Honorable Patricia Wald of the U.S. Court of Appeals for the District of Columbia Circuit and Honorable Nathaniel Jones of the United States Court of Appeals for the Sixth Circuit. Incidentally, Jones will be speaking tomorrow night, or tomorrow afternoon at 3 o'clock in Town 101 on the subject of legislative attempts to curb federal court jurisdiction.
Jen and I thought it might be interesting for you to just hear an explanation of how the participants got to this competition tonight. During one's first year at Harvard Law School, for those of you not aware of the process, a student is required to participate in one of the moot court competitions. That might be Jessup, it might be one of the Ames alternatives, or it might be the first year Ames competition run by Patricia this coming year. When one competes in the moot court competition the first year, that's it, and there's no further competition beyond that point, unless as a second year student one wants to compete in the qualifying round, coordinated by Greg Keller and Ann Cuddy. From the qualifying round, 4 teams go on to the semifinal round, and from the semifinal round, 2 teams come to this evening tonight. The issue presented tonight is an issue taken from a real case. The record before you, the joint appendix, was written by Dorian and Judy Bowman, and they presented the joint appendix that you have tonight that the 2 teams will be arguing this evening. The 2 teams are, I would like the teams to rise as I announce their names. For the appellants, we have Sarah Fox, Mary Higgins, Howell Jackson, Oralist Andrew W. Lowy, Michael Poindexter, and Hugh Winokur. On the appellants team, one of their participants last year was Tammy Logan, who is a team member for the previous rounds, but she's pursuing independent research for a fellowship this coming year. And for the appellees team, we have Louis Billionis, Nicholas Grabar, Leslie Ann Jones, Stephen Levitas, and Oralist Deval Patrick, and Oralist Lawrence Stasel. Final decision is made, or until the oralists at least have been given the opportunity to speak. We ask that you take no pictures during the competition, and we also ask that while the oralists are speaking that you do not get up and move around. No exiting, no intern for those of you not here yet. We have a reception following the argument, and we hope that you will come. Thank you.
Oyez, oyez, oyez. The Honorable Supreme Court of the United States is now in session. All persons having business before this court shall come forward and give their attention, and they shall be heard. God bless these United States and this honorable court.
Clerk, call the case. proceed.
May it please the court. My name is Michael Poindexter. My co-counsel is Andrew Lowy. Together with my colleagues on the brief, we represent the appellant, Lou McGuire. At issue here is a statute which permits the imprisonment of a criminal defendant without trial and without bail on the basis of a prediction that he will commit crimes unless he's jailed. Under that statute, Lou McGuire was held for almost 3 months awaiting trial after his arrest last December on a charge of burglary. He challenges that statute here on a number of independent constitutional grounds. As I will argue later, the pretrial detention statute violates the constitutional prohibition against punishment without conviction, as well as the excessive bail clause of the Eighth Amendment. Mr. Lowy will argue that the statute also contravenes the due process and equal protection clauses of the 14th Amendment. Before turning to those issues, however, I will address the threshold question of jurisdiction and Mr. McGuire's claim that his continuing personal stake in the outcome of this case makes it a live controversy justiciable under Article 3 of the Constitution. Under the Ames statute...
Well, it's good you're taking that up at the outset. I was a little surprised at the way that was handled in the briefs. You didn't deal with it until your reply brief.
That's correct, Your Honor.
Don't you think your explanation is a bit lame?
I've got no experience in judging those explanations, sir, and we offered our reasons and what we felt were justifications in that.
Well, the nearest to a justification is that you hadn't read our rules. This way you deprived us of the benefit of the appellee's response to your argument on mootness. Not to say of depriving the appellee of the benefit of having that privilege.
I hope the appellees will be able to deal with that tonight, Your Honor.
Well, I hope so too, but I don't think this should pass unnoticed.
May I proceed?
Yes.
Under the Ames statute, defendants charged with specifically defined crimes of violence are subject to pretrial incarceration when charged with a violent crime if they've been convicted of a similar crime within the past 10 years, are out on parole, probation, or bail for a similar crime at the time of their arrest, or if harmed or threatened to harm prospective jurors or witnesses. In addition, a judicial finding of dangerousness is required before a defendant may be incarcerated. The statute, however, allows dangerousness to be inferred from the defendant's prior
I thought
criminal...
you were going to talk about mootness.
I can go to mootness if Your Honor would like.
Well, it's the first thing we have to know, isn't it, whether we have any jurisdiction of this appeal?
Yes, Your Honor. The state argues that Lou McGuire's case is moot. He has no legal interest or redress since his pretrial detention is over. But the state concedes that appellant will again be exposed to the Ames statute if his conviction is reversed on appeal. This is, therefore, a case capable of repetition, and yet because of the limited duration of his pretrial confinement, one which persistently evades review. The theoretical existence of some class action alternative doesn't solve the problem faced by Lou McGuire.
Counsel, when your client was preventively detained, did you take an immediate appeal from the lower court's decision detaining?
The detention order?
Right.
That's correct, Your Honor.
And how long has it taken you to get up here to argue before us the legality or the illegality, rather, of that order?
Your Honor, that detention order was delivered December the 15th of last year, so we're here approximately 11 months later. His pretrial detention terminated in March of 1981.
What kind of order do you want us to enter if we agree with you on the merits?
We seek a declaratory judgment that the Ames statute here in question is unconstitutional for various...
As what? On its face or as applied?
Both on its face and as applied, Your Honor.
If we find it's unconstitutional as applied, why do we ever get to the question whether it's unconstitutional on its face?
That would not be necessary if you found that, Your Honor.
So then if we should find that it's unconstitutional as applied, it wouldn't necessarily be the same case if if his conviction were reversed and he was to be prosecuted again. The state might have more facts.
Your Honor,
Leave you in trouble on the mootness problem?
Your Honor, we're not asking that this court review the findings of fact made in the Ames state courts. We're arguing that this statute, because it allowed those findings to be made on the type of evidence that was presented, is unconstitutional on its face. It was also unconstitutional as applied to Lou McGuire. But that does not bother our mootness argument, Your Honor.
What is the facial infirmity of the statute?
That it allows the state to present its case against Lou McGuire on hearsay evidence which denies him a right of confrontation against his adverse witnesses, which is exactly what happened to Lou McGuire in this case.
Suppose there had been no hearsay evidence. How can we say that, should we condemn the statute even as applied to a case where there is no hearsay evidence?
Do you mean if the particular case had not been based on...
The identifying witness that turned up here, been cross-examined.
On that basis, Your Honor, we contend the statute is unconstitutional on Eighth Amendment grounds and on due process and equal protection grounds as well. The hearsay problem is merely one of the independent constitutional grounds that we challenge the statute on.
My difficulty is that it seems to me this question of what we're being asked to do and the mootness issue get a little intertwined. Because if all we find is that if we should find, for example, that the statute could properly be applied to a case where there was no hearsay evidence or where there was ample evidence other than this, but that it was not properly applied in this case, how can we decide anything that has any real bearing? Because we can't tell what would happen on a new hearing and McGuire's convictions reversed.
Your Honor, because the statute allows hearsay evidence and because it allows this incarceration, which is, we claim, punishment, to be entered without a formal finding of guilt, that renders the statute unconstitutional.
I know some of your arguments are addressed to the facial unconstitutionality. Others are not. And that's where it seems to me very difficult to say that this isn't moot. Never land between the two arguments.
Well, Your Honor, Mr. McGuire's appeal is currently pending before the Ames Supreme Court. If that appeal is reversed, he will again be subject to the provisions of the statute, whatever they are, regardless of whether the state finds new evidence against him or has less evidence at that time than it did in the initial.
In his appeal, which he's currently prosecuting from his conviction, is he making any allegations that his trial was in any way hindered by the period of preventive detention? Is he raising any of these points in the context of the conviction itself?
We have not made that claim, Your Honor.
Why not?
Because we were not his trial counsel, and the record of that trial is not on the record of this appeal. We're appealing strictly the order of detention rendered by the Ames Superior Court. As we claim, the theoretical existence of a class action does not solve Lou McGuire's problem, because if his conviction is reversed on appeal, he will again be faced with detention under the statute. The state suggests that he could bring a federal class action under 1983. As you know, this would not give Mr. McGuire the relief he seeks, because only a habeas corpus action can challenge the fact or duration of a confinement. The state alludes to a class habeas corpus action. The problem with that is that he would still need to exhaust his state remedies under that statute, and he would be before this court in exactly the same posture he is today. Furthermore, it would be completely inappropriate for a federal judge to grant some exception to the requirement of state exhaustion, since the Ames Supreme Court had not had a chance to interpret their own statute prior to this appeal. and possibly save it from constitutional infirmity. This is exactly the type of low-level, low-visibility deprivation that often occurs in our criminal justice system. It's the kind the court noted in Cibron, one which is frequently encountered, yet one which presents deep and abiding constitutional problems which would otherwise escape review. For that reason, this case ought not be moot.
Are you arguing, in addition, that he's suffering any collateral consequences from
Your Honor, there is
terminated period of detention?
There is at least one collateral consequence which Mr. McGuire definitely suffers. That is, if he's brought up on another pretrial detention hearing, the fact of this pretrial detention hearing under the Ames statute could be entered in evidence to the court and said, Your Honor, this individual was found dangerous at a pretrial detention hearing last year. We recommend that he find a...
You really think that since he's now been convicted of the offense and assuming that the conviction is upheld, that in any future preventive detention hearing that's likely to be more prejudicial to him than the fact of the conviction itself?
I don't know if it would be more prejudicial, Your Honor. It would certainly be cumulative. It would certainly add to the prejudice against him at a later hearing.
Do you have a money bail statute in the state of Ames?
Not on this record, Your Honor.
Well, I understand on the record that he was originally given $1,000 bail and made it, and then after a day or so, the preventive detention. So I gather from the record that indeed you do have money bail.
I would assume so.
In existence. Well, how is his situation so much worse off than those people who are incarcerated pretrial for more than 90 days for want of making the money bail?
There's a grave difference between holding someone in jail because they are unable to secure their appearance at trial.
You think it makes any difference to the person in jail?
A subjective test is not really appropriate here, Your Honor. The travails of people in jail are simply beyond the scope of this issue. The fact is that when a person is detained because a court has found that he can't be released without endangering the community, that constitutes the kind of condemnation that, coupled with the detention, creates punishment. Detention without that condemnation for the purpose of securing presence at trial is unfortunate, but in this case, it's necessary to ensure the continued operation of the judicial system. But what happened to Lou McGuire is completely unrelated to judicial administration. He was found dangerous and confined on that basis and that basis only. That is a traditionally punitive reason. And the state concedes that to impose punishment without a formal finding of guilt is constitutionally defective. The state also concedes that detention plus condemnation equals punishment. The only issue that remains for this court to decide is whether the circumstances of Lou McGuire's detention carried a sufficient measure of condemnation to complete the syllogism.
Well, isn't your syllogism something like this, that prevention is one objective of criminal punishment, and therefore anything that involves prevention must be criminal punishment? That doesn't seem to me to follow that.
Your Honor, prevention certainly is an element of punishment, and in this case perhaps a definitive element, but certainly not all preventive measures in and of themselves constitute punishment.
Isn't that what you're arguing to it?
No, Your Honor. Bringing a defendant to a swift and just trial is a preventive measure in that it brings people to justice as quickly as possible. That is certainly not a punishment.
No, but you argue, you cite cases that said quite correctly that certainly one objective of criminal conviction and imprisonment is to prevent commission of crimes during the period of detention. And therefore, you say that anything that involves that kind of prevention must necessarily be punishment, no matter what the state's objective is.
When it's coupled with a finding of dangerousness, Your Honor.
Would you rather have the finding eliminated from the statute?
Your Honor, the state is inferring dangerous here in an unacceptable fashion. They've not proven the fact that underlies that inference. The inference of dangerous is made on a criminal charge, an arrest. Without a trial and without a formal finding of guilt at which it was found beyond a reasonable doubt that the defendant committed the act, the inference is made from that act. So that
If they're going to have that kind of hearing and have him found guilty beyond a reasonable doubt, might as well have the jury in at that stage and convict him then and there.
we agree, Your Honor. Before you jail someone for 90 days because he's dangerous, he deserves a trial.
Mr. Poindexter, let me ask you to spell out in a little more detail what you referred to on what you're referring to on page 26 of your brief, where you talked about the less restrictive alternatives that are available to the state to prevent pretrial crime, reduce pretrial crime. What are some of these less
The first and foremost is a speedy and efficient trial, Your Honor. That gets the issue of fact out of the way. There's a clear and legally sufficient answer as to whether the defendant did commit the act or not. On that basis, punishment is completely appropriate if the defendant is found guilty.
But don't you have that here? Don't you have a speedy, I got it from the record here, that he went to trial. Did he go to trial on the ending of the 90 days?
90 days, Your Honor. It took 3 months in jail.
Most speedy trial statutes don't bring you to trial much before that. In fact, defense counsel sometimes object to coming to trial much before, a couple of months for preparation purposes.
Perhaps this would be a special exception to a Speedy Trial Act, Your Honor, in which, because of the defendant's past criminal record,
You can bring him to trial the same day?
If I'm sure the defendant might object, he might
sure he
need
might
time
too,
to
yeah.
prepare his defense, but we would certainly grant a trial before the end of 3 months imprisonment.
It hasn't proved practical to do that, has it?
Pardon me, Your Honor?
It hasn't proved very practical to do that. Courts are having a hard enough time living up to the 90-day period.
Your Honor,
Talk about it, but
compared to the expense of incarceration, it equals out.
expense, it's the availability of judges, lawyers, witnesses, rules that the defense wants to make before trial.
Well, Your Honor, if the defense moved for continuance, that would certainly toll the speedy trial portion for the period the defense requested.
What
But-
level of scrutiny, Mr. Poindexter, should this kind of a statute be subjected?
Well, Your Honor, on equal protection grounds, we argue strict scrutiny. In this case, the scrutiny should be simply that the state has adumbrated a list of reasons here that 5% of the time have proven to be accurate. 95% of the time they've proven to be inaccurate by the studies cited by appellants. Whatever the justifiable reason the state might present for this sort of incarceration is, 5% accuracy is simply not acceptable.
So we look to the state's objectives to see whether there's a relationship between the objective of the statute and some governmental purpose?
Your Honor, the governmental purpose here is explicitly stated to prevent the occurrence of crime before people come to trial. But
Your argument is that this is too broad and too nebulous?
No, the purpose is fine, but as applied to detention, it becomes an unacceptable purpose to detain someone under a judgment that the person is a danger to the community.
I mean, you consider this detention too broad a brush to be sweeping with under these circumstances?
Well, this statute certainly, because it sweeps 19 innocent people under its wing, as well as the one person who statistically might commit a crime pre-trial, it certainly sweeps too broadly to survive.
When you use those figures, aren't you forgetting the necessity of the judge finding that no other method will protect? Those statistics don't allow for that, do they?
Your Honor, the statute gives the judge no true criteria that he can apply in this case, but even if the state's purposes aren't necessarily infirm, and even if the court finds that this does not constitute punishment in the technical or constitutional sense, the statute is repugnant to the 8th Amendment of the United States Constitution because of the circumstances under which it denied bail to Lou McGuire in a non-capital case.
Are you going to argue the Eighth Amendment point, or is your colleague going to argue?
I was going to argue it, Your Honor.
Go ahead. Don't just say that the Eighth Amendment applies, because there's great doubt in my mind whether it does.
As the appellees concede, the true function of the excessive bail clause is to prohibit the abuse of bail. By denying bail here to Lou McGuire under a finding of dangerousness, instead of merely to secure his presence so that he could stand trial and receive a just determination of his guilt or innocence, the state of Ames has abused the right to bail just as certainly as if it outlawed it altogether.
I don't quite understand that, counsel. It seems to me that most of the historical material and the historical studies, the same ones that are cited by both you and appellees, pretty well lay out a pattern of history, certainly on the English side and even on the early colonial side, in which bail has been denied for offenses. Indeed, you may say they were capital offenses, but the number of offenses that were capital offenses in those days paralleled almost quite a bit what we now call felony offenses. It's really hard these days, isn't it, for you to make the straight argument that the right against excessive bail really means a right to bail in all cases. And even you don't argue the capital exception.
It's not so much a list of which offenses are and which offenses aren't that counts, Your Honor. The point is that capital offenses fall into the logic that no person will wait around to be tried if his life is on the line. Therefore, there is no monetary surety that can guarantee the presence of the accused.
What empirical studies do we have to show that that's any more true than the empirical studies which you cite rather contemptuously underlying the preventive detention? That's just an inference, the same logical inference that your opponents would draw from in a preventive detention statute.
Your Honor, our whole system of justice is founded on an inference that people can be deterred by the threat of punishment. Certainly no study shows that either. This is just an underpinning of the entire system we've inherited and have continued.
Well, it's the same kind of inference, I think, that the proponents of the statute would suggest that if you have committed a crime in the past, a crime of violence, either a conviction, parole, or probation, etc., and there's a halfway to reasonable doubt, namely substantial probability that you've committed it here, that it's a logical inference that you're a dangerous person that ought to be detained. Why isn't that an inference that can be accommodated in our jurisprudential system?
Your Honor, many, many people in our country and the world are dangerous persons, depending on the provocation they're faced with and the circumstances they're faced with. That danger may or may not come out. To imprison someone merely because you infer that that person is dangerous is just foreign to our system of jurisprudence.
But it's exactly what we've done in the capital exception, except that you have taken a particular type of offense at one extreme of the spectrum and said anybody who is suspected or has probable cause, less than substantial probability, that they have committed the capital offense, it is perfectly all right to infer that they are so caught up that they wouldn't possibly stay around for trial, and so therefore will imprison them. There's really nothing more to base that on logic than there is the other end of the spectrum in preventive
Perhaps
detention.
not, Your Honor, but it operates from a fundamentally different perspective, and that is that it's sometimes necessary to incarcerate people, capital defendants, those who threaten judges, jurors, or witnesses, to ensure that our system of jurisprudence will get a chance to work and find guilt or no guilt. But if that calculus does not apply, if you have a defendant who is not under that adverse motivation to flee or who is beyond the deterrent effect of current laws because he's already committed the most heinous crime and faces the most severe punishment, to incarcerate someone who has not crossed that line simply goes against the grain of the entire system. That's the argument we make here, that it's not the crime list itself of what is bailable and what is not bailable, but it's why. Why bail exists? Because we assume that people are deterred by the threat of punishment. If you change that assumption and round up the entire class of 1982 and say statistics show that 5% of you will commit violent crimes in the next 20 years, therefore you're all in jail, we're free of crime. An easy solution, but under our system of government, one that's strictly too drastic and infringes too heavily on individual rights. And that's why we challenge the statute on that basis in this case. That's why we say the Eighth Amendment must be read so as to include a right to pretrial freedom where the calculus works, in non-capital cases and in cases where there are...
Well, do you think that right against excessive bail is violated in your ordinary run-of-the-mill situation where, after a probable cause hearing, a judge looks at the defendant and no hearing at all in terms of hearsay or no hearsay, looks at his past record and says, I set $100,000 bail, which the defendant can't make, and so therefore I don't think there's any other condition which will allow me to be sure you'll show up for trial, so therefore if you can't make the bail, you spend the time in prison.
Stack v. Boyle said if the bail is set higher than that necessary to ensure appearance, then it's excessive. So in that case,
the judgment process by which you decide what is high enough to require to permit presence is not a hearing, is not a due process adversary confrontation type hearing. It's a judge looking at somebody's record and his community ties and saying, you're in or you're out.
None of those carry the condemnation of dangerousness, Your Honor.
But, well, let's stop there a minute. If you are in jail, and in most of our jurisdictions we have release on recognizance statutes, meaning that a so-called reliable defendant is allowed to get out without bail. If you're in jail for a long time because a judge has made a judgment that you cannot properly, reliably be released on your own recognizance, in fact, you are in there, are you not, to prevent you from committing the crime, and it would be a crime if you didn't show up for trial.
That would be a crime, Your Honor, but
so there'd be some stigma attached to that too, wouldn't
but
it?
certainly much less of a stigma than that attached to going out and creating acts of havoc and violence on the community.
That's your judgment, and it may indeed be correct, but it's an inference you're drawing.
I see your point, Your Honor. Thank you.
Thank you. Thank you. Mr. Lowy?
Yeah. May it please the court. I'm Andrew Lowy.
As you begin, I wonder whether you would tell us why Gerstein versus Pugh and Bell versus Wolfish are not controlling.
Your Honor, Gerstein is not controlling in this case because Gerstein involved a decision that needs to be made by a judicial officer as to whether there was probable cause after an arrest has been made. What was not at stake in Gerstein is extended preventive detention and the absolute denial of pretrial freedom, which is at stake in an Ames pretrial detention hearing. So the procedures that the court laid out in Gerstein for a probable cause hearing simply don't apply in this case.
Well, actually, the two defendants in Gerstein apparently stayed much longer in jail than Mr. McGuire.
They may have
their trial.
They may have, Your Honor.
One
but
because
those
it was a capital offense, and the other because he couldn't make bail.
That's correct, Your Honor. In that case, however, both defendants were granted access, as defendants normally would, to the traditional bail system. They had a bail hearing.
One was, the other wasn't.
Beg your pardon?
One was, the other wasn't. The one that was charged with a capital offense.
Well, presumably there was a hearing at which it was determined that bail would not be set for that defendant. In either case, they both...
There didn't need to be any hearing. The statute prohibited it.
I'm not sure that Gerstein says that the statute prohibited bail in that situation. I think it could be denied in that situation. Nevertheless,
he didn't get it because of a capital offense.
That's correct, Your Honor.
The judge was authorized to do that.
The procedures at a bail hearing, however, as Justice Wald has pointed out, are really substantially different than the kind of finding that's a finding of dangerousness that's involved in the Ames statute. At a bail hearing, there really are not disputed issues of fact. What's before the judge is the defendant's record and factual information, much of which, perhaps most of which, the defendant himself provides to the court in terms of his ties to the community and so forth. There aren't really disputed issues of fact which are involved at a bail hearing, and so additional procedures are not really required. But in a case like this, what's at stake is a much more complex finding, a finding that goes to the dangerousness of the defendant, and that kind of a more complex inquiry and the results of that inquiry, which would be the absolute denial of bail under any circumstances, demand a higher level of procedural protection than the court provided in Gerstein or that are provided at bail hearings. The Ames statute that's at issue here authorizes the preventive imprisonment of defendants prior to trial if those defendants have prior criminal records. And the state has, in effect, conceded that these statutory criteria are simply not accurate predictors of pretrial crime. The state has not challenged and, in fact, has cited as its own authority the leading studies in the field which indicate that these criteria used in the Ames statute are accurate in predicting pretrial violent crime only 5% of the time. Thus, what the question before the court, as far as substantive due process and equal protection is concerned, is really whether the Constitution permits the state to incarcerate potentially as many as 20 criminal defendants because of the statistical probability that one of those defendants would commit a crime prior to trial, a violent crime, that is, prior to trial. Now, the state evinces apparently little concern over the fact that the statute potentially sweeps far too broadly, sweeps into its reach a large number of defendants for whom there's no basis to believe that they would be dangerous.
Would you think the statute would pass constitutional muster if you had another study next year in which the 5% predictability was up to 50%, or let's get over the dividing line, 55%?
Your Honor,
or would you be back here still arguing that it was unconstitutional?
Your Honor, our point is not only that these criteria are not effective predictors of crime. It is that there are no effective predictors of violent pretrial crime. The only criteria that could be used that would even begin to approach the kind of close fit that the Constitution requires are criteria that would involve such characteristics as race, as sex, as age, as socioeconomic data.
So I assume that you, tell me if I'm wrong, would feel like most people that perhaps there are lots of unfairness in the money bail system too, that it penalizes the poor versus the rich. So if you also feel that society cannot move in this direction and it cannot say a finding of substantial probability plus a past record of committing a quote, dangerous crime entitles them to commit somebody, society is basically left with no options. No matter what the crime outside of a capital crime that the person is accused of, no matter what the record, it has no alternative but to leave him free for the period until it can bring him to trial. Is that bottom line to your position?
There are clearly, our position is that there are less restrictive alternatives. It is true that our position is that detention,
so you can
pretrial detention is not an alternative.
take away a little of his freedom. You can tell him he has to report, you can tell him he has to live in a halfway house, that he has to get a third-party custodian, that he can't drive, that he can't leave the country. You can take away some of his freedom on these, what you would call poor criteria. It's just, what do? You go right up to the edge of jail, but at the point of jail, it becomes unconstitutional?
That would be our position, Your Honor. And the reason is this, that once you're crossing that line and talking about imprisonment, you're talking about a far greater deprivation of liberty than is involved in any of the other measures you've cited. A deprivation of liberty that, as Your Honor is well aware, has a substantial impact on the likelihood that that person is going to be convicted, on the likelihood that that person is going to receive a much harsher sentence when he is convicted. Every study has shown that that whether or not a person is incarcerated prior to trial has tremendous impact. Now, that doesn't per se make any kind of pretrial incarceration unconstitutional, but it does mean that when you cross that line into and imprison somebody prior to trial, you are visiting on that person a far more substantial deprivation of liberty, and a deprivation of liberty that really requires that there be a very exacting level of scrutiny applied by the court.
But you're not too worried about the fellow who's in jail because a judge has decided that he's not reliable enough to show up for trial without a high money bond, and we don't even have an empirical study that shows 5% of those wouldn't show up. We just infer it logically.
Your Honor, I'm worried about those people too, but those people are not before the court in this case. It's not the issue that's before the court. I think that one reason that the state seems to evince so little concern about the possibility that large numbers of people will be swept unnecessarily into the reach of this statute is that, in effect, the operation of the statute serves to it operates in such a way that the state will never be confronted with evidence of its own mistakes. Once a defendant has been incarcerated, it's simply impossible to determine whether that defendant would have acted lawfully if he had been out on bail instead of in jail. In that sense, the statute is really self-reinforcing. If it appears to be reaching those defendants who, or some of those defendants who would commit pretrial crime, it appears to be working no matter how many defendants who are non-dangerous are at the same time incarcerated along with them.
Mr. Loy, I noticed, I was waiting for you to, in response to Justice Wald's question a moment ago about the degrees of deprivation, I was waiting for you to refer to a portion of your brief in which you made reference to a law review article written in 1975 in the University of Pennsylvania Law Review. And I wonder whether you're abandoning that argument that you incorporated in your brief, or did you just fail to mention it? I think the author was the Chief Justice of this court.
That is correct. That is correct, Your Honor. Do you mean, are we abandoning the argument that there are procedural?
You cited that law review article, and it sounds rather persuasive to me, and I wondered why you did not use this occasion to raise it.
I simply thought that
because the article was about administrative proceedings and not about trials.
That's correct. We only cited Your Honor's article in reference to its specific reference as to deprivations of liberty being of a very high order.
No one takes this lightly, but is it really true that nothing effective the state can do in an extreme case? Suppose you had a bank robbery, and in the course of a perfectly lawful search of the robber's apartment, they found dozens of plans to rob other banks they couldn't identify, the police couldn't identify. They just can't do anything.
Well, Your Honor,
by putting those people away for 60 or 90 days until they're tried.
Your Honor, the reason they cannot is that none of the criteria that are available to us, to anybody, there are no criteria that exist today that are in any way accurate in predicting future pretrial violent crime.
Why did they have these plans of the other banks around? Just, were they collecting plans of banks? No collectibles are all the rage now, but...
Your Honor, I'd respectfully suggest that the likelihood that they would carry out those plans after already having been arrested for in their first attempt would make it highly unlikely that they would continue in that effort. It would certainly seem to pose grave risks to them.
Well, Mr. McGuire waited only 25 days after he was released on parole before he, at least as the state alleges, strayed from the righteous path.
As the state alleges. The question is, what evidence does the state have? And we suggest that there is no evidence.
Had a case where they had really strong evidence. 6 bishops saw him do this.
Your Honor, our point is that if such evidence existed, that would be a different case, although it would certainly not undermine the independent constitutional challenges that we raise and that counsel has talked about.
I'm puzzled as to whether you're really saying that this statute is facially unconstitutional. There are no conceivable circumstances under which it could be properly applied, or whether you're relying on the peculiar problems of this case.
No, Your Honor, our challenge is to the facial constitutionality of this statute. The reference to the incarceration of Mr. McGuire really serves as an example of how that statute operates, but our challenge is, our claim is that under the Equal Protection Clause, under the Due Process Clause, and under the claims that my co-counsel has discussed, that the statute cannot stand. It's, in terms of equal protection and due process, it simply acts with so much imprecision. It sweeps into its reach so many people on a basis that really is unfounded in terms of whether or not they're dangerous, that it simply cannot meet the exacting level of scrutiny required by the Constitution. And those claims aside, we further believe that the procedural protections provided by the statute are woefully inadequate. And using Mr. McGuire's, just the case of Mr. McGuire's incarceration as an example, shows how inadequate those safeguards really are.
Which safeguards are so inadequate? Are you speaking just primarily or solely about the lack of a right of confrontation as to one's accusers? Because otherwise he can have counsel, he can put on whatever witnesses he wants to.
The lack of any right to confront and cross-examine adverse witnesses.
Well, he has the right to confront them if they're available.
That's in this case, of course, and in any similar case.
Well, has this court ever held that the Confrontation Clause was violated because of the state's failure to produce a witness who wasn't available?
Your Honor, it would be violated if the state then presented hearsay evidence
even in the criminal trial itself. Sure, it may be a violation of the hearsay rule if that was part of the state's law. Your client would be entitled to a reversal in the state courts. But has the Supreme Court ever said that a violation, that in a case where the witness wasn't available, the use of hearsay testimony violates the Sixth Amendment? That was one of the big points of the distinction the court has drawn between the hearsay rule and the Confrontation Clause.
Well, Your Honor, I'm not sure whether under the Confrontation Clause they've made such a holding. Our point is not that this proceeding would be subject to the provisions of the Sixth Amendment. It's obviously not a criminal trial, but in every kind of proceeding where important decisions have been based on disputed findings of fact, the court has mandated that a defendant be allowed to confront and cross-examine adverse witnesses. That right is plainly denied in this situation.
Well, for example, in Morrissey against Brewer, the Chief Justice was at some pains to say that there was the parole revocation case, as you know, that the defendant had the right to confront the witnesses if available.
Your Honor, I think that Morrissey quite clearly held that it was not simply a matter of whether those witnesses were available. I'm quite sure that Morrissey and Gagnon both provided for confrontation and cross-examination of adverse witnesses, only with the exception that if the state could show that there was good cause to believe that a witness might be in danger, that otherwise the burden was on the state to produce that witness. That is, Your Honor, at the preliminary probation or parole revocation proceeding. Now, I think there is a looser exception that is provided later on at the actual final revocation proceeding. But at the proceeding that Gagnon and Morrissey both dealt with that is comparable to this one, in other words, the preliminary decision which would send a parolee or probationer back to the penitentiary for a 60-day period, at that point confrontation, I believe, must be provided unless the state can show good cause that the witness would be in danger. Aside, Your Honor, from the issue of confrontation, however, The substantial probability standard that the state supplies for the statute is further evidence of its infirmity under procedural due process analysis. The substantial probability standard is simply a standard that has no established history in American jurisprudence.
It has an established history on the civil side. We talk all the time about the standard for injunction and stay, substantial probability of prevailing on appeal.
Well, Your Honor, on the civil side, it is true, one of a large number of terms that courts have applied.
Well, my only point, I won't belabor it because you have a limited amount of time, is it's not a term that's totally foreign to our jurisprudence, and it certainly carries with it some connotation of something more than probable cause, which, at least under one interpretation of Gerstein v. Pugh, not yours, I'm sure, would say that upon a probable cause, you can go ahead and hold a person in jail if they can't make bail for trial. And that's less than substantial probability.
Your Honor, unlike the situation where a preliminary injunction is involved, here we're dealing with a decision that if erroneous, involves the necessary incarceration of a criminal defendant for 90 days. The state Supreme Court could only identify the substantial probability standard as lying somewhere between the showing that the state must make to establish probable cause and the clear and convincing standard. Even the state Supreme Court was unable to say whether or not the substantial probability standard was more or less than a preponderance of the evidence. And in those circumstances, courts simply do not have the kind of guidance that they must in order to decide what kind
I thought the state court said it was somewhere between preponderance and clear and convincing.
No, Your Honor, the record was quite clear. The court said that it was somewhere between the showing necessary to establish probable cause.
Oh, yes, probable cause.
Right. In other words, so our point is that they have not even identified whether or not it's above or below a preponderance standard.
Well, getting back to our friend Morrissey and Brewer, the court says there's a narrow inquiry. This is the final hearing, which is, of course, much more formal than the earlier one. There's a narrow inquiry. The process should be flexible enough to consider evidence, including letters, affidavits, and other material that will not be admissible in an adversary criminal trial. Why doesn't that include hearsay?
Your Honor is absolutely correct. I was referring to the initial, the
Well, the initial hearing is a nothing, really. Has to be, because it has to be done very promptly at a place where witnesses may not be available and so forth. It's the final hearing where more procedural protection is given.
Your Honor, I'm sure that the decision does state that as far as both in Gagnon and in Morrissey, that as far as the preliminary hearing to determine parole or probation revocation, only when the state can show good cause as to why a witness should not be, can show in fact that a witness would be endangered by appearing, are confrontational rights waived. But even assuming assume for the moment that my reading is wrong, what's at stake in Morrissey is a much lower level there's a much lower level of liberty interest that's at stake in Morrissey. In Morrissey, we're dealing with what the court has called conditional liberty. We're dealing in Morrissey with a convicted felon who is serving his sentence, has been released on probation, on parole or probation, and might be sent back to jail to continue that sentence. Here we're dealing with somebody who has not yet been convicted of a crime, and the much higher level of, much higher liberty interest at stake here compels even a higher degree of process than the court provided in Morrissey and Gagnon. I thank the court.
Thank you, Mr. Hall. I'll hear from the appellees, Mr. Stossel.
May it please the court. My name is Lawrence Stasel, and together with my co-counsel, Wald Patrick.
What's the pronunciation of your name, sir?
Stasel, sir.
Stasel?
Yes, Your Honor. Together with my co-counsel, Wald Patrick, and our colleagues on the brief, we represent the people of the state of Ames. This case concerns the state's power to detain certain defendants between arrest and trial in order to protect the safety of the community. Now, we fully intend to address the merits of this case, but before we do that, there is a preliminary jurisdictional matter that must be addressed. In short, we contend this court has no power to hear this case. The reason is that an actual controversy, as required by Article 3 of the Constitution, no longer exists between Mr. McGuire and the state of Ames. And Mr. McGuire's challenge on this appeal is that his pretrial detention was unconstitutional. At this time, that pretrial detention is over. Therefore, there is no dispute that this court is capable of resolving.
Well, if I understand your argument, you're suggesting that since, as I asked appellant's counsel, they got up here as fast as they could, they took their appeal, that was through no dilatory tactics, that they didn't get here sooner than they did, so we can assume the same thing would happen on the next time around if he were preventively detained. Your suggestion is every time somebody is preventively detained, their counsel has to drop his defense of his particular client and run out and start a class action in the federal court or in the state court and attack frontally the preventive detention statute. Now, is that really either practical or is it really necessitated by a case or controversy requirement here? Isn't it highly onerous burden to put on a criminal defense?
In the first place, Your Honor, the question of the evasion of review is not simply a discretionary issue. It is a question that goes to this court's jurisdiction. Now, appellant has claimed that they fall within the special situation of jurisdiction in which the Southern Pacific Doctrine defines the boundaries of Article 3. There are two requirements under that doctrine. Not merely that the statute evades review, which we don't...
Likelihood of repetition and capable of evading review, right.
And in this case, because such a series of speculative events would be required before this appellant would be faced with the challenge process all over again, that aspect of the test is not met. And additionally, the statute, we argue, does not evade review. So what I'm suggesting is that we simply don't look to the second aspect of it before we address what are the realistic
It does evade review. Your point is that under the Southern Pacific Doctrine, it's the particular person who must show that he'll suffer. But hasn't the defendant done enough by alluding to this possibility of reversal of his conviction and repetition of this performance?
Your Honor, the existence of a separate pending appeal on state criminal conviction has never been held to demonstrate the required reasonable expectations that this court has held as the necessary standard of expectation before capability of repetition.
Well, I don't think the question's been presented, but what do you say about the two cases that the appellant cites in the reply brief on pages 2 and 3?
Your Honor, appellant cites the case of VTech v. Jones, but VTech did not involve a separate pending criminal conviction, the outcome of which would in any way affect the likelihood of repetition of that case. In VTech, this court simply held that a prisoner who had been subjected to unconstitutional transfer procedures stood a reasonable expectation of being subjected to those transfer procedures again since he was back in prison. And the case does not in any way stand for the proposition that the existence of an ancillary appeal on a criminal conviction in state court provides the requisite demonstrated probability that this court held in Weinstein was the proper standard for repetition.
How about Pennsylvania against Mims?
Pennsylvania against Mims, Your Honor, was a case that involved the doctrine of collateral consequences as yet another area of the movement.
But it wasn't an appeal by the defendant, it was an appeal by the state.
That's correct, Your Honor.
The state didn't suffer any collateral consequences. It only suffered lack of collateral consequences only suffered the possibility of adverse effect if there were another criminal prosecution. Why isn't that very close to this case?
In Pennsylvania v. Mims, the court held that the state would suffer certain collateral consequences in future trials if the evidentiary standards that were at stake in that case came out the way they did. It also cited in a...
You mean in cases involving other defendants?
That's right. That's right. But the case involves an entirely distinct area of the mootness inquiry than the issue of capability of repetition.
I don't know what the particular issue was in Pennsylvania against Mims, but I'd thought from reading the reply brief that these adverse consequences the state was worrying about related to the particular defendant. At least that's what the appellants say in the sentence at the bottom of page 2 and going over to page 3. They say the state's interest was entirely contingent upon the defendants being charged with another crime. Is that right or wrong?
I believe that's correct, Your Honor.
Well, then isn't that coming pretty close to this case?
No, it isn't, Your Honor, because the concerns in the collateral consequences area of the mootness inquiry are that, in the usual instance, that the defendant would suffer adverse legal consequences as a result of a criminal conviction. In this case,
sure, the case where the defendant is appealing after he served his, or bringing some collateral remedy after he served his sentence are clearly indistinguishable, but that wasn't the situation here. In Pennsylvania against Mims, it was the state that was.
But, Your Honor, I think that the case didn't involve an inquiry into the reasonableness of repetition, but if it did, I think a concern was that the state would be burdened in every criminal conviction as a result of this holding, not merely in the particular case that involved that defendant. Now, in addition, as we
well, why don't we have some analogy to the collateral consequences here for this man? What is wrong with the argument, or what is erroneous about the argument that it's one thing to be convicted of a crime, it's another thing to have been convicted of the crime, which could still be reversed on appeal, and also have a finding by a judge that you have been dangerous enough to be, not even to be allowed to have your liberty pending trial?
There simply are no adverse legal consequences that can attend to this finding.
Well, they can. Well, don't jump so fast. I mean, why are there not some consequences? Not only on his record, it's a form, it's a finding, it's a judgmental finding that he was too dangerous to be allowed out in the community pending trial. Now, all by itself, even regardless of what consequences it had upon, if any, upon his subsequent conviction. Why isn't that like a mini conviction on his record? He certainly could, if it had been a conviction, he certainly could have, even though he was out of jail, he could have appealed it. It wouldn't have been moot. Why isn't this a form? If, after all, if the state is willing to create a new form called preventive detention, then maybe it has to be willing to recognize a new form of stigma, namely finding that you're preventively detainable.
That may be so, Your Honor. I would take issue with the following, that as the doctrine stands, one, the only adverse consequences are ones that are deemed to be legal adverse consequences. Appellant has only suggested that this information might be used against him in some later pretrial detention hearing were that to occur. But if one looks closely at the way that the statute is structured, there is no place in the finding by a judge with respect to the statutory inquiry that allows for that kind of information to be used in order to detain someone. All one looks to are the criteria with respect to whether a past crime was committed, whether there's substantial probability of the present crime having been committed, and whether there are any conditions of release that will satisfy the safety of the community.
And what are those conditions? That he's rootless, that he doesn't have any employment? What else?
Well, the conditions are usually tangible ones that deal with whether there is some work release program that could be established, whether there are people that could take him into custody, that sort of thing.
Now let's...
And to show you pardon me, go ahead.
No, please.
To show you the problem that arises from this, we merely look at McGuire's case, where during the course of the hearing, the probation officer came in or the parole officer came in and testified that this parolee was without employment. And that was factored in, was it not?
Yes, Your Honor, but all those would be reconsidered at a later hearing, which is where appellant...
But the fact that it was factored in shows the mischief. Now, why didn't they go further and inquire as to whether he was looking for employment, or whether the unemployment rate was 40% for a person of his particular age group, or what have you? There are all kinds. This statute seems to invite all kinds of misapplication of rules, which can result in the result that lead to the result that we have here. Now, let me just ask you what this statute is intended to accomplish is to create an intermediate category of punishment for a person who is socially obnoxious or has a track record which some prosecutors and police chiefs and police officers may find troublesome.
If we're now turning to the merits, then I'm fully prepared to discuss the issue of
Well,
whether
no, let's go back to the statute itself. Here's a statute that creates a process whereby a person can be detained prior to being convicted of anything. And a whole scheme of procedure is set in motion. And following the playing out of this scheme or this scenario, a person can be put in jail, not on the basis of a conviction beyond existence of reasonable doubt, but because of a court or some hearing officer finding substantial probability that an offense has been committed. Is that not providing a rationale for locking people up prior to adjudicating their guilt?
it provides a rationale for locking certain defendants up prior to an adjudication of guilt. Now, the challenges that...
Now, where do we find justification for that in the Constitution, with the presumption of innocence that we have?
The presumption of innocence, Your Honor, has been held most recently in Bell v. Wolfish to refer to an evidentiary standard, or a standard with respect to a burden of persuasion in criminal trials, and has not been held, in that case at least, to refer to the pre-trial process at all. Now, the question really is, I believe, is there a right in the Constitution that the appellant can look to show that the state has somehow denied him something that is his due? Now, the way that the right has been raised by appellant is first that there is some right to pretrial release, except where it would otherwise be impossible to secure a defendant's presence.
But there is a constitutional guarantee of presumption of innocence, is there not?
There is an overriding theme that one does not assume guilt prior to trial. But this is a regulatory measure designed to protect the safety's community, which is perfectly within the state's power, at least that idea. And the question is, have they transgressed any rights that the Constitution establishes for an individual who has entered the criminal process? Now, the first right that appellant looks to the first place that the appellant looks to locate such a right is in the Eighth Amendment, as we've heard tonight. More specifically, that part of the Eighth Amendment, which states that excessive bail shall not be required. Historically, though, in England and in this country, that clause has always been understood to refer to a check against the misuse of bail. That is, a check against the practice of purposely setting the rate too high.
Let me ask you a question. Suppose the Ames legislature said, well, enough of these halfway measures. Now, crime is a terrible problem here, and everybody who's arrested and has a probable cause hearing to show that they have committed a crime, never mind what kind, goes to jail until they can be tried at the end of the 90 days. That's it. No exceptions.
Obviously,
that's constitutional?
That would be a much more difficult case.
I'm sure it would be, but is it constitutional by your analysis?
By our analysis, there may be a right within the 14th Amendment that at least begins to talk about what happens to a defendant in the run-of-the-mill case prior to trial. And there may be certain problems with the rationality of that classification, that anyone who commits a crime with substantial probability is deemed to be dangerous and therefore can be detained prior to trial. Now, we would argue that the Eighth Amendment simply does not address that problem, because as this court held in Carlson v. Landon, the excessive bail clause does not represent a constitutional commitment about pretrial release in general. In fact, it doesn't address itself to the issue at all. So the question in your hypothetical, Your Honor, would be, is there some problem with the classification that's involved? And with respect to the equal protection and due process challenges to this statute, my co-counsel will address those issues. But in the meantime, we argue that it's not presumptively valid, but this case is certainly a much more different. Now, if the Eighth Amendment then doesn't address the issue of pretrial,
apparently the Eighth Amendment addresses nothing under your analysis.
Not at all, Your Honor.
It's surplusage.
Not at all, Your Honor. The Eighth Amendment addresses exactly what it says. It addresses the issue of where a judge purposely sets an amount of bail too high, or where the judge misuses what the
It
purpose...
doesn't say that. It doesn't say the Eighth Amendment, no judge shall set excessive bail. It says excessive bail shall not be required. Suppose the legislature passed a law which said $100,000 bail for every a petty larceny case.
Again, Your Honor...
That's not our case, I know, but
no. Your Honor, in that case, it would be a difficult decision to decide whether the excessive bail clause referred to that, because the judiciary has traditionally, and as far as I know has always, been the only body, the only branch of government that has actually set bail. If the legislature were to start a practice of setting actual money amounts for bail for specific crimes, then perhaps the Eighth Amendment would refer to that. But
if the legislature says no bail, then it's under your analysis, the Eighth Amendment has no
That's correct, Your Honor. If the Eighth Amendment, as read historically and has always been understood in this country and in England, then doesn't address this specific issue, appellant must show that the purposes of the Ames statute are somehow inconsistent with the scheme of American justice, or the tradition and the consensus about how our criminal process operates. In fact, they have shown...
Not just the purposes. It also would need to worry about the means used toward the purposes if you're operating on a due process analysis, wouldn't you?
Yes, Your Honor. But this court, in every case that it has found that that a right exists for a criminal defendant in a state court, has looked to see whether it fit in with the fundamental scheme of American justice as has been understood through history and through tradition. And in this case, appellant has come forward with no evidence that such a constitutional prohibition exists against the specific purposes that the state has invoked here. In fact, this court in Carlson v. Landon suggested that the purposes in a case that involved the detention prior to deportation proceedings of aliens held that, in fact, the excessive bail clause was not implicated, and also that the purpose of preventing danger to the community was a legitimate purpose.
That was the same year they decided, or the same term they decided, Stack v. Boyle, in which they said, yes, in which they said that bail should never be set at a level which was any higher than that needed to ensure presence at trial. And I think it's a fair analysis, counsel, that the scholars and everybody else have been debating for however many years, 20, 25, exactly what it meant to have those two ships passing in the night in the same term.
You're suggesting that Carlson is not absolutely conclusive on it.
I am suggesting Carlson is not absolutely conclusive. You read me rightly, counsel.
I would agree, Your Honor, except I would suggest that Stack v. Boyle is not as applicable in this case, in that Stack referred
I'd concede it's a wash for that term. And so why don't you can continue your analysis.
I'm not so ready to concede that they cancel each other out, Your Honor. I think that for the purposes of this case, Stack referred to the fixing of bail and only referred at most to the excessive bail clause, and perhaps was decided, although it's somewhat unclear, and Justice Jackson takes the majority of the task for doing so, but it's somewhat unclear whether that case was not determined under the Federal Rule 46, which existed at that time and never even addressed the constitutional issue. Carlson seems somewhat closer to the case that we have. There's further evidence also, affirmative evidence, that the purposes for restricting pretrial release have not solely been confined to those two purposes that appellant argues. For example, in capital cases where bail has traditionally been denied, there is nothing to suggest that the only reason for that denial has been that in order to secure the presence of those defendants at trial. And in fact, in the federal bail statute in 1966, in section 3148, the Congress explicitly recognized that dangerousness was a legitimate purpose to consider when thinking about whether or not to grant bail to capital defendants. Furthermore, there's no general consensus with respect to the states that the securing of defendants' presence at trial and the protection of witnesses are the only acceptable purposes for restricting pretrial release. 9 states, as we cite in our brief, either through constitutions or statute, recognize that those purposes are not the only ones.
And many states refuse bail in cases beyond capital cases that are not capital cases, don't they? By statute.
I'm sorry.
I mean, many states have statutes which make non-bailable offenses other than capital offenses.
That's correct, Your Honor. Finally, if I might just address for a moment an issue that seems to have been somewhat soft-pedaled by appellant in this case, but Your Honor seemed to be concerned about it. There is no right to pretrial release on the basis that this would be necessary to effectuate the right to a fair trial under the Sixth Amendment. Historically, the right to a fair trial has never been so understood to include an absolute right to pretrial release, that in cases involving denials of bail or where bail cannot be made, there's no question that those defendants share the same right to a fair trial as every other defendant. It simply has not been held that a necessary ingredient of that fair trial right is one that requires pretrial release. The court seemed to establish that connection in Bell v. Wolfish, and finally, there's simply no evidence in this case that the criminal conviction of appellant was the result of anything but the fairest of trials. Appellant's second major constitutional argument is that this statute constitutes punishment without an adjudication of guilt. The definition of punishment is indeed a murky issue and one that has arisen in a variety of contexts. But the precise issue here is whether the state of Ames can do what it did to Mr. McGuire without a conviction for a crime. We argue that the answer to that is, in fact, that it can do that. Appellant concedes that the fact of detention alone does not necessarily amount to punishment. So the important thing to consider is the meaning which attaches to that detention, the message that it conveys. And here, the message is clearly not a punitive one.
What is this message?
In fact, Your Honor, there is no explicit message being sent to the It is the absence of a punitive message that we say.
The message is that this person is dangerous and can't be trusted at liberty. Is that the message?
Your Honor, I think that's
a judgment that's been made.
Excuse me?
That's a judgment that has been rendered by some tribunal.
The judgment is more that there are no conditions of release that at the moment would satisfy the safety of the community.
So that makes him dangerous.
Excuse me?
That makes him dangerous, doesn't it?
That means that he poses a risk of danger.
And you say that's not a message?
We say that does not amount to condemnation, which is necessary for punishment.
You think people do not cross the street when they see him, if they were to see him coming?
If the state has its way, Your Honor, that person won't be coming to someone.
Well, what if he's acquitted? What if he's ultimately acquitted?
If he's ultimately acquitted, we suggest that because this is merely a prelude to a full trial, that if he's ultimately acquitted, that the system in its full trial form has then made the statement that it is making to the community at large, that this person is not guilty of the crime and is not someone to be shunned by the community. If, in fact, the person is convicted, as appellant was in this case, it is hard to imagine an additional significant quantum of stigma being attached to someone who has then been convicted of a crime.
Now, to come back to the real world, if a person is acquitted after having been determined to be dangerous, do you think that acquittal, ipso facto, will cleanse him of all stigma?
I think it would, Your Honor.
And
additionally, this
How could it in many situations? I mean, again, in my colleague Judge's real world, very often you're acquitted for all sorts of things because the jury couldn't say beyond a reasonable doubt because a witness didn't show up because of a variety of circumstances. And yet that defendant would leave the courtroom free to walk on the street with a judge having decided after a hearing with some kind of evidence made a finding that there was no condition or combination of any condition of release known to the judicial mind that would reasonably assure the safety of that person in the community. Now, how can you realistically say that with that as a finding by a judge that he hasn't been mini-convicted is the only word I can describe it with.
Presented in that extreme form, there may be perhaps lingering effects to the defendant, but this court has never
Lingering effects are called collateral consequences legally, I think, aren't they?
There
Sometimes.
may be those, although not of a legal nature, as we suggested in the mootness discussion. But this court has never held that the mere effects on an individual are what are the determinative measure of punishment. This court in Kennedy versus Mendoza-Martinez explicitly rejected the notion that we look to the effects on the individual, but rather we look to the purposes which underlie that statute. In this case, the purposes of the state are not to condemn someone for past acts, not to exemplify this person.
How about in re Winship, when it looked at the juvenile delinquency statutes, which had been supposed to have nothing but a rehabilitative purpose? I mean, that said in every one throughout the country, they looked at the quantum of proof that was necessary to convict, not even convict, adjudicate a juvenile of a crime, and said, it looks like something akin to a criminal conviction, enough for us to insist upon beyond a reasonable doubt. Now, the purpose of every one of those juvenile statutes was to rehabilitate, and yet the court in those decisions, in re Galt and in re Winship, did look at the effects. They weren't solely determinative, but they certainly looked at the effects. They described in great detail what it was like to be a juvenile and incarcerated in a training school. I don't think you can say, can you, that courts ignore the effects. They may not be solely determinative, but they don't ignore the effects in deciding what's punishment.
Your Honor, I assume you'll grant time for me to answer the question, even though that red light is on.
With my colleagues' indulgence, I will.
Julie.
In re Winship was a case where the statute specifically said that if this person is between 8 and 15 years old, that person is considered to be a delinquent. But the effect was that the statute referred to any criminal conviction. In other words, it said that if this person, but for the fact that he is between 8 and 15 years old, does an act which would amount to a criminal conviction were committed by someone who is over the age of 15, then that person is considered to be delinquent. And the court found that that was simply too transparent a condemnation that to be evaded by the mere words that this is rehabilitated. In this case, the state has done nothing to say that this is a bad person to be shunned by the community for past acts. It has simply said that there are no conditions of release that will satisfy the safety of the community.
But it's also said that the judge must have made a finding that there is a, quote, substantial probability that the person committed the offense for which he's present before the judicial officer, so that it's certainly not divorced totally from consideration of what the actual criminal act is.
No, but I think the statute, as my co-counsel will suggest, is tailored to achieve the minimum that is necessary, or to invoke the minimum that is necessary to achieve the end it seeks, which is the prevention of crime. So I yield the floor to my co-counsel, Patricia. Thank you.
All right, Mr. Patrick. Yes, please.
Justice. Thank you, sir, and may it please the court. The remaining issues before the court this evening go to those 14th Amendment arguments of Mr. McGuire. Before I get there, I think it's important that the court remember and keep before it the context in which this case arises. 3 weeks after his release on parole from an 8-year sentence for armed robbery, Mr. McGuire was indicted for another crime of violence. Now, because of that arrest, because of his criminal history, and the nature of that arrest, the district attorney moved for the hearing called for under this statute to consider whether detaining Mr. McGuire was the only way, that is, detaining him until trial, was the only way to assure public safety. His 2 remaining challenges go to, and I'm simplifying here, first of all, the basis on which he was brought to that hearing, that is the use of his criminal history to forecast risk to the community, and the fairness of the procedures the statute provides to consider really ways to diminish the court's concern. And in the first instance, Mr. McGuire is claiming that criminal history is an imprecise way of inferring criminal risk, and that the statute should therefore fail. And the parties are agreed, and they have been all along, that these criteria at the first level are imperfect, but that doesn't make them any less rational. And the court has so held in the case of Marshall against the United States. And in fact, the studies that you've heard bantered, that you saw bantered around in the briefs, and again brought up at argument, show at least a relationship between criminal history and the court's, or a reasonable concern for criminal risk, but the statute doesn't stop there, and it's important that it doesn't stop there. Judge Newman in the trial court was required to make two further findings, to resolve, in a sense, two further questions. The first was it substantially probable that Mr. McGuire had committed burglary? And the second was, were there no conditions of release which would assure public safety? In the first instance, in finding substantial probability, the Ames Supreme Court required that Judge Newman be satisfied that the state had more than enough evidence to support a suspicion that Mr. McGuire had committed burglary, but that she not require so much that she be unequivocally convinced of it. Now the challenge to that, and the only challenge to that statute that the appellant has brought forward, is that it's vague. We argued in the brief, and we believe correctly, that the vagueness doctrine doesn't apply, but that really is...
How do you get around the case of Jockcha against Pennsylvania, which the other side cited?
Well, Your Honor...
I first thought you were probably right on that, but when I read that case, I began to wonder.
Your Honor, in the first instance, and we agree, Jockcha does give us some problems because it isn't so clear.
How do you answer?
It isn't so clear in that case, although the court in that case did acknowledge that it was conduct that the vagueness doctrine usually addresses. The court said that the problem with the statute was that the state court findings, which had developed over the years to construe the statute, hadn't made it any less specific than it was on its face. And even if the vagueness doctrine...
That made it any more specific.
That's right. That's right. Thank you. Really what Mr. McGuire seems to be complaining is not that vagueness as a constitutional question makes the substantial probability standard improper or infirm, but in a sense that because the Ames Supreme Court construed substantial probability for the first time in his case, really his counsel did not have time or did not understand how to get ready for this hearing, how to be able to meet the state's evidence. Now, if there were a record to sustain that argument, there might be due process implications. But the record here shows that in the first instance, Mr. McGuire, though he now says that he was confused at the hearing, he never asked for clarification. There was no indication there's no indication in the record, and on this appeal, Mr. McGuire has brought forward no indication that he was prejudiced in any way by his supposed lack of understanding about what substantial probability meant in fact, or what, in fact, evidence he would have entered in the hearing had he known what substantial probability was. And even after the hearing was over, after the judge made the required findings, the statute contemplates Mr. McGuire being able to bring forward evidence, in a sense, to displace the state's showing and to get right back into court and reopen the issue.
But what kind of evidence could he have? Now, what you had here, as the record shows, is that the identifying witness was, quote, unavailable. And so you had the policeman giving his account of what the only witness, the only eyewitness. You didn't even have the equivalent of a Wade lineup. I mean, you had the policeman saying that somebody he never saw before and doesn't know much about came up and described somebody and said they saw that somebody breaking into a warehouse. Policeman ascertained, not even according to this record, that there'd been an actual burglary, but that there was such a warehouse with a window pane broken and a lock jimmied, whatever. And then had this other fellow who didn't show up identify him on the street. Then this fellow disappears, apparently, is not at his known address, and I quote to the record here, the policeman testifies that when he rode with him in the car and they saw this fellow walking down the street, he says, I asked Mr. Robinson to get out of the car and look again, and he said, quote, it looks like him. That's the sole piece of identification you have by hearsay, even by the policeman's hearsay, is that somebody he doesn't know and can't locate said about this defendant, it looks like him.
Well, Your Honor, that really goes...
Is that substantial probability?
Judge Newman apparently thought it was. And if the court is asking, first of all, questions that relate to the second claim that Mr. McGuire has fought for, that is that the hearsay admitted in the case was really unfairly admitted. In the first place, just going to the, well, I was going to go to the record first. Go to the broad question, that is whether hearsay should be allowed in this setting. And the appellant agrees in his brief, that the method that the court has shown us for asking the question whether hearsay is appropriate in these situations, or indeed the question whether additional procedure is appropriate, is to take in the first instance the private interest involved, in this case, that liberty interest by a criminal defendant, of a criminal defendant, between arrest and trial. The public interest, which in this case concededly substantial, of protecting people from the risk of bail crime, and then asking whether requiring confrontation in this case would have added anything to the fact-finding process in light of the interests at stake. And
you think it wouldn't have?
Well, in this case, Your Honor, and in all cases, it's important to reconstruct the scene into which the hearsay came. We're in a courtroom. Mr. McGuire is there. He's before a trained, neutral judge with the opportunity to assess.
Yeah, but the trained neutral judge never had the opportunity to assess the credibility of the eyewitness who identified Mr. McGuire.
Precisely so.
Let's assume the policeman was telling honest, that was the most credible witness that ever appeared. It's what he said and what was in his capacity to say that's disturbing, at least in light of our, to some of us, in light of our background. It's not the fact that the judge and the policeman could exchange information.
Well, no, Your Honor, but it's not divorced from that fact. The point is, again, that the court has required us in the past to look at the whole context and ask whether hearsay would have added anything, whether excluding hearsay would have added anything.
I'll tell you what excluding hearsay, it would have subtracted something so that you would have had nothing. If you hadn't had hearsay here, you would have had nothing, and you couldn't have made any kind of a finding, because it would have been nothing.
That's certainly true, but, well, let's go to the record. In their brief, in his brief, the appellant says, in effect, that the only significant discrepancy between Mr. Robinson's description and Officer Polster's description was that Mr. Robinson saw dark hair and dark trousers, and Polster saw light hair and light trousers. And then in their brief, appellant goes on to say that the light was worse for Mr. Robinson than it was for Polster. And if there are concerns about bias or prejudice on the part of the absent and out-of-court declarant, no one is in a better position to know that than Mr. McGuire himself, and all the statute required of Mr. McGuire's counsel is that she stand up and say so.
Mr. McGuire never, I mean, it's conceivable or not, that he never saw this man before. That I don't understand your point about how he would be in the best position to raise any questions about the veracity of someone that isn't in the courtroom, that he doesn't know who he is, where he came from. This man might have been a mental case. He might have been a paranoiac. He might have been a well-known informant, a dope addict, a whole series of things which there's no opportunity for the... I don't wish to take any more of your valuable time. I'm simply making the point that hits one. If this statute is capable of being applied to a record like this, it raises, I think, and highlights some of the constitutional problems with permitting an absence of confrontation.
Well, Your Honor, in the first place, as we've said, it's impossible to argue that it isn't always better to have an out-of-court declarant present. But the court has instructed us that that is not the inquiry. The court is not going to look to how to write a better statute, but to ask instead whether, with the private and public interest at stake here, as I outlined, and with the presence of legal technicians and other formalities, admission of, well, really whether it's necessary to have confrontation in every case or to leave it to the fact finder. And if you look at the cases, Madam Justice Wald, that we cite to support that theory, the court has done precisely that. It looks to the whole scene. I'm now thinking of cases like, for instance, Morrissey against Brewer, where hearsay is allowed, at least at the preliminary hearing, as a first step for at least a deprivation of at most 2 months. VTEC against Jones, for instance, where the court required hearsay because there was no judicial fact finder, although it said that there had to be an independent fact finder. In other words, the court is looking at all the factors and trying to decide whether, given what has to be accomplished, and given what a criminal defendant in this case needs to have protected, and should have protected and respected, the addition of the requirement of confrontation in every case is necessary. And effectively, our argument has been all along that with a hearing before a neutral fact finder, and with Mr. McGuire represented by counsel, a hearing on the record, specific findings required by the judge, having to be explained in a written opinion, and all this record and the opinion with the assistance and help of briefs and counsel going up for full direct review before the state Supreme Court is enough to ensure that hearsay will be given its proper weight. And that is the inquiry the court has shown us.
Mr. Patrick, let me ask you this question. Same question I asked your co-counsel. Does not this statute, the Ames statute, create a new classification of offenders or offenses? Is that not what this statute seeks to do? That is an intermediate definition of socially obnoxious conduct, which can lead to the power of the state coming down to protect the rest of us?
Well, no, Your Honor. And the reason is that I think what's happening is you're concerned about the appellant's really kind of conclusory characterization of the statute as being a loose finding of dangerousness. That's not what's required.
Well, you said a moment ago, and maybe I'm taking what you said out of context or misapplying it, you used the term bail crime. What were you referring to when you talked about a bail crime?
I'm sorry, that's a shorthand, really. But
is that a crime that one is charged with committing while on bail?
Or released before trial.
So then then we are trying to get to a the legislature was trying to address a category of a conduct that occurs during a certain period of time between arrest and conviction.
That's correct. But the statute doesn't respond to an act having occurred as usual punitive statutes do. It's a prospective measure in the sense that it tries to use this, at least in the first instance, a very broad class of persons with a history of violent crime who have been charged with a violent crime, narrowing that by the second level inquiry, that is the inquiry into substantial probability, to only those people against whom the state is likely to be able to prove its case. And then through the last inquiry, that is the reasonable doubt, not the reasonable doubt, the reasonable conditions of release inquiry, looking at particular circumstances in a defendant's own environment, which will assure the court that there need be no concern.
What are the criteria that a court is to look at?
Well, in this case,
where can you direct us to some criteria, definition, legislative history that will help us or help a court that's faced with this problem determine what is substantial probability, for instance?
Well, and I wish we had some legislative history. It would certainly make.
Well, isn't that one of the problems? Isn't that one of the problems with this statute?
That may be one of the problems, Your Honor, but I don't believe the court is in the habit of striking down statutes because the state doesn't write its debates. If the court is
well, certainly those who have to enforce, those who have to apply the law and enforce the law have to have some guidance as to what the intent of the legislature was.
Well, Your Honor, the intent seems to be able to be divined, if you will, from the
Divine, I think you used the right term. I think divine is just what I think that aptly describes
Well, but look
what a court has to do.
Look at what happened here. In the first instance, Judge Newman heard, on the conditions of release question. First instance, Judge Newman heard testimony from Mr. McGuire's parole officer that he had no job, no local relatives, and no close associates.
But what does that mean?
Your Honor, it means a great deal. First of all, undisputed information.
Does that mean any person does that mean any person who has served time and who is presently unemployed can be considered as likely to have committed a crime?
No, that's not what it means, Your Honor. What it means is now we're at the last inquiry that the court has to make. What it meant in this case is that Judge Newman had enough information to apply what she called the usual conditions of release, and we can imagine what they were. Parole supervision, for example, would have been unsatisfactory. We knew. And
Did the parole officer say that?
The parole that's not a conclusion that the statute requires the parole officer to make. The statute requires that the judge be presented with information for the judge to make a conclusion. And we know because Mr. McGuire committed, or at least was alleged to have committed a crime. I hesitate to say committed because his appeal is pending on the conviction, but committed a crime while he was on parole and while he was supervised, so that was unsatisfactory. We know release into custody was unsatisfactory because he had no local family or relative. We know, for instance, that work release was impossible because he had no job, and even then, the inquiry need not have been closed. Mr. McGuire is still in a position to come forward with alternatives. In fact, Judge Newman asked him if he would be willing to, if he was prepared to put forward that kind of information, and he said no.
Well, let us just consider for a moment the part of the record dealing with the testimony of the parole officer. Carol Wagner, who was asked, she said she was a parole officer in Ames City. Question, are you the parole officer for Lou McGuire? Yes, I am. Question, can you tell us where the defendant resides? And she gave the address and so forth. Do you know whether the defendant lives there alone? Answer, he has told me that he does. Question, does he have any relatives in the city? Answer, he has told me that he does not. Question, is he currently employed? The last time I spoke with him on December 9th, 1980, he told me he was not. Mr. Moses, I have no further questions, and no further questions, and the witness was excused. Nobody bothered to ask this parole officer whether this person had sought employment, whether the parole officer had interceded to help him get employment. There was no development of circumstances which could have perhaps explained the fact that this person was unemployed.
Of course but you said it yourself, Your Honor, nobody bothered. And who's in a better position to do it than Mr. McGuire, who has counsel there? In fact, Judge Newman asked him, as I said, whether Ms. Fredericks, Mr. McGuire's counsel, would be asking questions, and she declined it.
But now what you've done there is raise a question which causes me to have considerable concern over this whole approach. And that is this creation of the reason I keep coming to this one question, whether we have created a new classification of crime, and whether we have shifted the burden now onto a person who ordinarily has certain constitutional guarantees and certain presumptions to which he or she can avail themselves in a criminal proceeding. And this seems to, I'm just wondering whether or not this is a shorthand way or a backdoor effort on the part of the state to deal with people that it finds somewhat difficult.
I hope not, Your Honor, and I don't think so. The state's interest in the case and in this statute is to protect people from the risk of crime committed between arrest and trial.
But are there not less intrusive and less sweeping ways of accomplishing that?
There may be, Your Honor. We've been able to find none, and it's our position that those that have been shown brought forward by the appellant don't help us at all. In fact, most of them were available, and most of them were conditions of release, which, as I said, Judge Newman would have considered. The point is that the reason the appellant has asked about and brought forward these less restrictive alternatives is in this kind of cloud of fundamental rights analysis that they suggest in their brief. The state has never contended that Mr. McGuire does not have a fundamental right to liberty. like any other individual in this constitutional scheme, only that fundamental rights analysis is a term of art in constitutional jurisprudence, does not apply to liberty deprivations in the criminal process. And that's because, unlike other so-called fundamental rights, the Constitution is specific about how and when a state may intrude upon the liberty of a criminal suspect. And that's the probable cause. And that does not mean that the state's responsibility, that the state can do whatever it wants at that point, or that, in this case, the state of Ames's responsibility ended with the probable cause hearing. But it does mean that the way the Constitution calls upon the state to express its respect for Mr. McGuire's liberty interest is to provide him fair process.
Why couldn't the state have moved to revoke McGuire's parole?
Excuse me, Your Honor?
Why couldn't the state have avoided all this by moving to revoke McGuire's parole?
You mean, and avoided having a statute at all, sir?
No, avoided this particular case from arising.
I suppose that was the state's mistake.
They went to the trouble of calling the probation officer and the parole officer to testify about this person's reporting habits, living habits. All this parole officer has to do is just to violate the person. In fact, parole officers have great discretion and authority, and once they had this person under these circumstances, parole officers are able to go in and have the person cited in and adjudicated a parole violator and shipped back. That's a less restrictive way of, that's a way that's more restrictive than this whole process.
Well, of course, it only deals. I see my time is up, but just to respond to that, sir, that procedure only deals with the people in this class of persons that the state is concerned with who are on parole. It doesn't deal with the whole group of people.
Well, they had a fellow with whom they could have dealt in that way. I don't know why they didn't. I suppose that's not relevant. Or alternatively, you could argue that this, in effect, was a violation of his conditions of parole, and that all these other valid on that ground, however it might be in some other case.
I have one.
You gave the answer.
I didn't argue.
With the indulgence of my colleagues, I have one last question. I'm intrigued whether or not the proof in this case could even have risen to what we call in an analogous Fourth Amendment context of probable cause, a reliable informant. Now, even before a policeman can depend upon an informer's evidence that he saw a crime take place or that something has taken place in order to get a search warrant or possibly even to make a Terry stop or an arrest, certainly, that informant has to be, or at least we've been told, has to be a reliable informant in most cases. He never saw this man before and apparently never saw him afterwards.
You mean
Wasn't
Mr. McGuire? Or
no, Mr. Robinson. I mean, there wasn't
even.
even.
Did Mr. McGuire never see?
No,
Mr.
I mean
Robinson?
the policeman. The policeman. After all, the policeman acted only pursuant to Mr. Robinson's information, and yet Mr. Robinson, like a phantom in the night, came and went. That wouldn't even, it seems to me, rise to the dimension of a reliable informant. At least we don't have any evidence in the record that he had any reason to think he was reliable. Now, you're suggesting, nevertheless, that we can detain somebody for 30 days on a finding of substantial probability with evidence that probably wouldn't justify a Terry stop or a search warrant.
Well, Your Honor, that's not so. In the
Why
first
isn't it
case,
so?
I've tried. In the first case, the record is just not broad enough to offer.
Well, that's we're being asked to uphold a man's detention for 30 days on the basis of this record. So I don't think you can tell us the record just isn't good enough.
No, that's not where I'm going. The record isn't broad enough to tell us what sort of relationship or communication Officer Polsher had with Mr. Robinson after the time he died.
Wasn't that part of the prosecution's duty to put that information in the record?
Not according to the statute, Your Honor, and if the court's concern is that the statute is infirm for that reason, constitutionally, we found no basis for that conclusion. If the court's concern is that substantial probability is not a constitutionally sufficient standard for detaining people between arrest and trial.
We can only look at the way the statute is applied in this case.
That's
I mean,
right.
at least we can look. We can't only look there, but we certainly can look.
But your inquiry ought to be into whether a reasonable fact finder could have made these kinds of conclusions based on the evidence presented.
Right.
And if we think it's not, we could render whatever form of relief we're being asked to do, which is still somewhat unclear to me, and dispose of this case and leave other problems under the statute for another day.
That would have to be the result, I'm afraid. As interesting as it might be to get to the merits in this case. Just to leave you with a thought, the statute is spawned, once again, by conceitedly substantial interest. That doesn't mean Mr. McGuire's interest isn't also substantial, but that his interest is informed by the Fourth Amendment.
But do we not have a duty to examine whether there are methods to address that concern that are less sweeping and less onerous than the methods provided for under the statute?
Well, again, Mr. Justice Jones, your concern seems to be with the level of scrutiny that the state is required to show, or that the court is required to use to review the statute. And again, because this is couched in the criminal process, not couched in it because it's grounded in the criminal process, the court's inquiry is not into less restrictive alternatives. It's in the first instance whether it's a rational classification, and then after that, whether the process that the statute affords is fair in terms of narrowing the class step by step as it does through these three levels until the statute fits. It's a little like buying a suit off the rack and having it fit. And what happens is, I should point out too that this is a less that it's important that the findings required by the statute are specific. That is, that it isn't a criminal defendant being brought into a courtroom before a judge, even with all this process, and then.
But isn't there a big to-do made about some of these findings? Number one, that this is the person who had been convicted some years past. I mean, that's who's going to quarrel with that? And that this is the person who has been subsequently arrested. So you have those two findings, which part of virtue concede that, because it's all a matter of record.
Sure. What's the court's concern?
You're talking about these findings that must be made by a neutral trier of the fact. Well, those preliminary findings are virtually just boilerplate stuff, isn't it?
Well,
what we're really getting down to is this question of substantial probability.
That's right.
And yet there's no criteria provided to guide the triers of the fact as to what should be considered outside of employment, this sort of thing.
Well, no, wait a minute now. The criteria about employment and job and the availability of family locally who could take custody of the defendant does not go to substantial probability. That goes to the conditions of.
I know. I understand it.
And again, it's not just the class isn't reduced merely by the finding that the defendant substantially probably committed this crime. It gets even closer by favoring release in a sense and saying that if there's any other way to release this defendant, given the concern of the state that people with this kind of with these kinds of characteristics may be dangerous for the short period between arrest and trial, then a judge is required to release that.
So if a person has no relatives in the town, that makes him dangerous. If a person may be unemployed, it makes him dangerous.
That's not it. That's not it, Your Honor. Those are the threshold showings, and that's all. The statute, because it's flexible in that way, contemplates creative alternatives. The point is that if the state is to be able to use the statute, then it seems the state ought to be required to make threshold showings and then to allow Mr. McGuire to come up with other alternatives. If Mr. McGuire's attorney, for example, had said that she was willing to assume custody, it's over. He goes. The inquiry, in other words, doesn't end by looking at parole supervision, whether he has a family member nearby or a job. It goes further, but what's required to take it further is Mr. McGuire, at least to some extent. And he did nothing in this case, even when asked by Judge Newman.
I think we have to ask you to desist, Mr. Patrick.
I'm sorry, I've gone too long. Thank you.
Appellants have reserved a couple minutes for rebuttal.
Your Honor, unless the court has further questions, please waive the rebuttal.
All right, thank you. We'll adjourn a few minutes. Mr. Lowy asked if we had any further questions, and we said no. I think that was not a very candid answer. We could have very much enjoyed asking counsel for both sides questions from now until the early morning, because the case presents so many difficult and interesting issues. But I think we probably asked enough, perhaps too much. As usual in these Ames Competition arguments and in similar ones in other law schools, the briefs and argument were of a very high caliber. Unfortunately, they were much better than the common or even the uncommon run of what we get in real life. And accordingly, the choices we have to make are extremely difficult. We've decided, although these decisions were painfully arrived at, that the best team was the appellee. On the other hand, we thought that although this was a very close call, that the best brief, or in this case a set of briefs, was the appellant's, and that the reply brief was particularly good. The final item is the award of the best oralist, who is also the winner of the George Leisure Award, and we've decided to confer that distinction on Mr. Patrick. Yeah!